class. Welcome back. It's been a crazy couple of weeks, and I hope that all of you are healthy and safe. And I have expressed to each one of you on at least 2 occasions now in your grading videos that I do want to hear from you if you need any kind of accommodations at all. This is a time where we are going to let some of these rules that we have established for the class slide a bit. And so I do want to encourage you to reach out to me if you need exceptions or if there's anything else that I can do to provide support. I want to do 2 things for the rest of this semester. We have 5 weeks left. The first thing I want to do is I want to make sure that you have time and energy to take care of yourself. Right now I'm sitting at my dining room table from whence I have been directing a home school for the last 2 weeks and will continue to do so. So I understand that there are new challenges that have come into our lives, and I want to do everything I can to help you meet them. The other thing I want to do is make sure that you get what you need out of this class. Public service is more important than ever, and everything that all of you are doing, several of you are working on the front lines of this, and I appreciate and I'm so grateful to everything that you do. And knowing the law, working within the law, and using the law to get to a public aim is more important than it was when this class started. And it was always extremely important. So I am hoping that I can continue to give you tools that you can use to immediately get into your work and make it happen. Because your work is so important, and I want to help it. So if there's any way that I can do either of those things, please reach out to me at any time. Today, we're not going to go through the readings. I hope that you've read my article, my encyclopedia entry on HR law for public administration. I think public servants need to know that the HR law is different for public servants. And so I've tried to outline how it's different in that article. If you have any questions about that, please feel free to text me. I really look forward to hearing your comments on it. Because it's an encyclopedia entry and an online encyclopedia, I get to update it whenever I want. So if there are things that you think need to be updated, please let me know so that I can go in and clarify or update them. Today we're going to go over 10 cases that will be on the final exam and 1 that will not. I just want to introduce it so that you know some of the history there. These 10 cases, again, are like all the other cases. What you really need to know is the rule and how you can use that rule. The quiz then is going to be testing your ability to use these rules, not so much testing your knowledge of the cases, but testing how you can use the rules from these cases to make different arguments. And that's what the final exam is going to look like, because that is the real skill behind the law, is if you can take the law, understand the rules, and apply them to regular life in the life of public servants. The first case is Pickering versus Board of Education. This is a phenomenally important case. One of the most important cases that we'll be talking about all semester. The only other case that's even marginally as important is Marbury versus Madison. This case says that you have to balance effectiveness with the First Amendment. Pickering versus Board of Education started in 1961 when a teacher sent a letter to a newspaper that was complaining about the school board. And the issue here is, what are the free speech rights of public employees, especially teachers? The court decided that probably discharging a public employee or doing any sort of action against an employee requires taking a balancing test between the interest of the employee as a citizen in commenting on public concern and the interest of the state as an employer in promoting the efficiency of public services. And they mean efficient and effective public service as it's been updated. And the public services it performs through its employees. In other words, the public deserves to know the things that public servants know, but also government should be able to run functionally. And that is why you need to have a Pickering test. You need to have those balanced. Now, that's a pretty loosey-goosey test. So a lot of the cases that followed up were trying to make sense of what exactly that test meant. For example, Garcetti versus Ceballos in 2006 held that a district attorney who decided that he wasn't going to pursue a case that the government wanted to pursue could be fired for not doing his job. Essentially, he thought the government had mistreated somebody and was suing them and harassing them. And he said, I'm not going to go along with a suit that he believed was unethical when the government had done wrong. Well, the government could fire him for that because the government needs to be able to have effective and efficient administration, including someone to file their lawsuits for them. And that's what a DA's job is. In Brickey versus Hall, a police force had a slightly different role. And this was a 2016 case in which the Fourth Circuit. And in this case, a police officer was running for city council, and he accused the police chief of graft, of stealing funds. This is clearly political speech, exactly the kind of political speech that seemed to be protected by Pickering. However, because it was so divisive to the department, in this case, the court held that the police officer could be fired because that police officer had really undermined the discipline of the department. There's some indication in this case that it was about the fact that police are so paramilitary and that they need to have that military style discipline. However, in a similar case that was released at the same time by the same court in the Fourth Circuit, Lane versus Anderson, it said, well, maybe police aren't a special case. And this photo, I don't know what this is, but it was one of the free photos that came with the software. So I decided I got to post that at some point. I think that's Officer Hop from that Animal Metropolis, whatever. At any rate, Lane versus Anderson was at the same time, and it was another police officer. But in this case, the police officer had said open things on television, saying that there was a cover-up going on in the police force, and but he wasn't running for office. It wasn't as divisive, and so they said, well, you have to go back and consider several factors. And these are the factors that were used in the Brickey case. And what are these factors? Well, the factors are, let's see, factors relevant to the efficiency and effectiveness of government that they were: 1, discipline; 2, harmony of the department; 3, personal relationships within the department and maintaining those; 4, the employee's ability to perform their job; 5, institutional operations and how important it is to maintain institutional operations; 6, coherence of the mission; 7, public or private communications; 8, tension with official responsibilities. In other words, if you're saying something that goes against your official responsibilities, sort of like Garcetti. 9, abuse of the employee's role or position. Those are all things that can get you fired, even if you're speaking on a public, using your First Amendment right to speak about a public issue. Now, notice that it's really important that if you're speaking on a public issue, that is more protected than if you're speaking on a private issue or an issue about your personnel, right? Or an issue about your wages or whatever. That's protected by different laws. And those are the laws that I talked about in the HR piece. Those are union laws mostly. And right to complain and whistleblow about employees' safety. Another case was Heffernan, and this was an interesting case. It was the same year, but this time we're in front of the Supreme Court. And in the case of Heffernan, it's really unusual because they were wrong. The police force was mistaken. The guy went to pick up a sign that was for an opposing police chief. And he went to pick up this sign for his mother. He wasn't actually supporting the opposing police chief. He was loyal to his police chief. And so the question was, well, that's not First Amendment speech because he didn't mean to communicate anything politically. So he can be fired because it's not protected by the First Amendment. That was the argument. It got all the way to the Supreme Court. The Supreme Court said, no, that's ridiculous. Even if you're not meaning to make a political speech, if the police department thinks that it's political speech, they can't fire you. So oops, in other words, it's no excuse. Now, moving on to the rights of religious people and to rights of religion. American Humanist versus City of Ocala is the most recent case in this way. And it says the governments cannot proselytize. It said essentially this police force was holding prayer vigils and ordering people to fervently pray so that the rate of crime would go down, regardless of the efficacy of that public service tool. And it might be efficacious or not. The Supreme Court held that indeed this was not constitutional because there is a clause in the First Amendment that says you cannot establish a religion, and government agencies cannot establish a religion. That means they cannot advocate for one religion over any other. Probably had he had several different prayer groups and several different faith leaders from several different religions present on that chain, the police force probably would have been okay. It is strict scrutiny when you're going against religion, so you have to have a compelling state interest, and the law has to be narrowly tailored so that there is no least restrictive alternative available. Rational basis is different, right? It's almost anything goes, right? When you have a rational basis, it only has to be a legitimate interest. Legitimate government interest, and it just has to be rationally related to that legitimate government interest. Any decision that it has to overcome rational basis has to be merely rationally related to legitimate government interest. So, for example, if you were to make a decision based on people who own trees, if you were to make a decision about all the people who owned trees, it would just have to be rationally related to a legitimate government interest. Except Romer versus Evans, which is where they decided to say something more. It looks like it's rational basis plus something more. Probably they call it rational basis with bite. Romer versus Evans was an amendment to the Colorado State Constitution that prohibited any laws or actions by any government in the state of Colorado that would protect gay people or lesbians. Anybody who's homosexual or identified as homosexual could not be protected by government. Not that they could attack them, but they could not protect them. And the court said, you know what? When there is animus, they seem to say that something about the animus behind just going after discriminating against one particular group, that is not a legitimate government interest, so that does not count. But generally speaking, you can discriminate against one particular group, like tree owners. If you were to discriminate against tree owners and regulate them in some way by saying, hey, all trees have to be no more than 10 feet tall, that would be perfectly legitimate. The Constitution would have nothing to say about it. But something about being gay changed that. And made them think maybe this is somebody who's being discriminated against and we need to protect a little bit more. So they invented this new category, rational basis with bite. Intermediate scrutiny was invented in Craig versus Boren in 1976. And this is a case where, despite, I know that you're thinking, sex discrimination, right? And it's got to be women who are discriminated against. Well, not in this case. In this case, men between the ages of 18 and 21 were not allowed to buy full-strength beer in some states. Women were, or girls really, between 18 and 21 were permitted to buy full-strength beer, but men were not. And the court decided that is unfair. Men should be able to buy a beer if women are able to buy a beer at the same strength. Not just 3-2 beers, they need to be able to buy the full-strength stuff. And so that's why we have intermediate scrutiny, which is something between strict scrutiny and rational basis. It was invented because we wanted to protect men who wanted to buy beer on their 19th birthday. And we've had strict scrutiny, though, for a long time. One of the most recent cases is Ricci versus DeStefano, which was about firefighters. In this case, the city held a firefighter's exam, and the firefighter's exam turned out to be discriminatory against Blacks and Latinx firefighters. As a result, the city shut it down. But the white firefighters who had placed 1, 2, and 3 and were going to get promotions as a result of this promotion exam, they complained and sued. And they said it was racial discrimination. Because they were white, their test was being invalidated because the city said it was discriminatory. But the court said, look, you don't have enough information saying that this is discriminatory. It might be job related, and it just happens to be in this case that all Blacks and Latinx people could not be managers, did not have what it takes to be a fire captain in this particular fire department. That's what the court essentially said. And the court then said, you have to reinstate this test and give those people the promotions, the white men and one Latino, the promotions that they earned with that first test. But then it got complicated because in Marciello versus City of Buffalo Police Department, they said, look, we have this test. It's discriminatory. We're not promoting anyone. We don't need to promote anyone right now, but we're going to administer a new test that we know is less discriminatory and then promote people after that. Well, the white person who got the highest grade on the discriminatory test complained and sued. In this case, the court said, look, you can do another test you can give another test. That is the least discriminatory alternative, right? That's what we're looking for. The least discriminatory alternative for a compelling state interest. Finding a good firefighter, finding the best possible firefighter is clearly a compelling state interest. And giving a second test that is less discriminatory, they're saying, is least discriminatory alternative, as opposed to just invalidating the first test, right? So there's the difference. That's not least discriminatory, but the other one is, right? So these are the kinds of cases that we're looking at when we're dealing with race and gender in front of the Supreme Court. One exception, though, and that's Morton versus Mancari, which seems to be a race case, but the court held that it wasn't, because in this case it was about the Department of the Interior Bureau of Indian Affairs, which since 1824 has been directing affairs between the Indian tribes and the federal government. Congress has special powers and special responsibility to deal with Indian tribes. And in this, they developed this agency. This agency was, for a long time, run almost exclusively by white people, but recently they decided, look, we're going to start hiring, we're going to have a hiring preference for people who are tribally affiliated. If you belong to one of the tribes that we manage, you should be able to join the agency because you should have more say over how tribes are treated, right? That's the logic behind it. It seems to be about race. It seems to be about American Indians. But the court says, no, this isn't actually about race. Silly you. You thought it was about race. But in fact, it's about affiliation with a tribe. It's about if you're a member of this nation that is being managed, right, this little agency that's being managed by the agency, by the BIA, then you have a right. Then you have the hiring preference. It's not racially related because it's not race. It's rational basis, which instead of having to be the least restrictive alternative, the least discriminatory alternative for a compelling state interest, for a rational basis, it only has to be a legitimate government interest and it has to be rationally related. Clearly, it's both, and that hiring preference survives. And so those are the 10 cases plus one. And which is the one that you don't need to remember? This one. You don't need to remember Craig versus Boring on intermediate scrutiny. I know it's a fun one, but I'm not going to be testing on it. Intermediate scrutiny is not used very often outside of sex sex discrimination. We don't have a lot of time. Sex discrimination is a really complicated topic, and we don't have a lot of time to go deep into sex discrimination. If anyone is interested in learning more about sex discrimination law, it is something that I happen to be an expert in, and I can certainly talk to you about it or give you some readings if you'd like. So please reach out to me at any time. As you know, I'm really eager to hear from you. My number is 970-236-6311. You can text me there, you can call me there, or you can join my Zoom meeting room, which is the same number that is my phone number at 970-236-6311. I'm going on Zoom right now to answer your questions, and I hope to see some of you there.